Good morning, and welcome to the second argument of the February 2022 oral arguments before the Kansas Court of Appeals. My name is Sarah Warner, and I will be presiding over today's proceedings. And before I call this second case, I'd like to take a second again to introduce our panel of judges. So Judge Amy Klein is a member of our court, and she's joining us from Wichita. And Judge Rachel Pickering, we're thrilled to have joining us from Topeka. Judge Pickering serves as a district court judge in Shawnee County and, of course, was an experienced appellate lawyer before she joined the bench. In preparation for today's argument, we have thoroughly reviewed all of your briefs and the record, and in this case, the administrative record before us. But even though we're familiar with the facts of the case, I have asked appellant's attorney to provide a little bit of a background before we get started with the argument, just to provide some contextual background for anyone who happens to be watching on YouTube today. The case before us is scheduled for 15 minutes of oral argument. I, as the presiding judge, will be keeping time, including any rebuttal time by the appellant. So at this time, I would like to call the second case on this morning's docket, case number 122804 from the Board of Tax Appeals in the matter of the appeal of Capital Electric Line Builders Incorporated from an order of the Division of Taxation on assessment of retailers' sales tax. Will the parties please state their appearances?
This is Lucky DeFries, appearing on behalf of Capital Electric Line Builders.
And Your Honors, Jay Bedford appears on behalf of the Kansas Department of Revenue.
Mr. DeFries, would you like to reserve any time for rebuttal?
I would like to reserve 5 minutes if I could, Judge.
5 minutes are granted. Counsel, you may begin.
May it please the court, with respect to an overview of this matter, I would like to recognize also with me today one of my partners, Trevor Wolford, who has been working with me on this matter. And I'd like to also acknowledge Jeff Weatharn, who unfortunately due to some health issues that he's dealing with, is not able to be here, but he also has been instrumental in working on this appeal. It's clear what this matter has been about. My client provides certain services, electrical contracting services. In connection with that, they enter into very detailed contracts. I think that's been detailed in our brief at this point. In connection with those, what's brought us here today is an argument from the department that in addition to the tax that's been collected on the services that my client provided to their customers, they also need to remit an additional tax in connection with services that they consumed, paid tax on, and have not been resold. That's the issue that brings us here today. And in fact, I think I'm glad you asked to have a brief overview with respect to that, because over the years I've been told that I try and err on the side of diplomacy, and I will again today. But we were disappointed and concerned that the nature of the case as represented in the department's brief here suggested that somehow we were attempting to pass through certain taxes that had been collected and not remitted. And I think as we indicated in our brief very clearly, that is not now, nor has ever been the issue in this case. The issue is specifically what I indicated it just was. That's always been what it's been about. And I think even the department later in their brief acknowledged as much. But I think that's the essence of what brings us here today, Judge.
Thank you.
I think as I just indicated, the issue is not what was represented as part of the nature of the case. We did indicate in our brief that to the extent the department had misstated or gone too far, we would have been anxious for them to correct the record. That has not taken place at this point. We'll be anxious to hear what the basis for that suggestion was as part of their arguments here today. So now on to what this case really is about that I just mentioned. There's three things that I'd like to focus on today, if I might. First of all, the burden of proof and how that intersects with the basic sales and use tax principles. Secondly, an attempt to really disregard the Cessna decision, which was a decision rendered by one of your predecessor panels. And then thirdly, this is not overhead. And there's no significance to the department's attempt to inject the term or concept of personal services, which finds no support anywhere within Kansas law, statutes, definitions, anywhere. First of all, with regard to the burden of proof, I think that's significant in this case. As this court's aware, if we were dealing with an exemption, the burden would be on us. To the contrary, though, in this instance, we're talking about an imposition statute. The burden is on the department to bring themselves clearly within the ability to impose tax in this particular situation. And I think, as this court is well aware, even if there were any sort of ambiguity, that ambiguity would have to be resolved in favor of my client in this particular situation. But I believe there's an additional burden here because, as this court is aware, and I know as you've read, the Cessna case is very much on point in this particular situation. And the department has now had just a couple of months shy of 8 years to try and offer some sort of distinction with respect to the Cessna decision. So far, they've been unable to do that. The travel services and the rental of equipment are both services paid for and consumed by Capital Electric. One deals with the mobilization and the necessary mechanical needs in this situation, but they're clearly equivalent services with no meaningful difference.
Counsel, there is a meaningful difference though, isn't there? Because in your contract, you say that one of those is going to be reimbursed at cost and one of those is going to be reimbursed at cost plus 10%. So what is that meaningful difference?
Okay. Well, I think substantively, we believe that they are very much equivalent. I think, as you can appreciate, if you're dealing with some of this very specialized, sometimes very large equipment, it's not unexpected that you might have to spend some time and effort to pick up the equipment and then to return the equipment. So what we're talking about is an additional 10% fee. It was very clear. The contract specified it was cost plus the 10%, but all that's being passed through is the actual cost associated with rental equipment plus the 10%, which clearly was attributable to some of the additional time and effort necessary to pick up and then redeliver the equipment at the end of the contract. But in terms of the substance of what we're dealing with, we don't believe there's any material difference between the type of services that you're providing, that both, in the Cessna case, the department indicated those travel services were necessary. In this instance, clearly the rental of the equipment was necessary as well.
Counsel, as I read the Cessna case, counsel, it looks like there was a provision in that contract for the specific reimbursement of travel expenses. And so I have before me the administrative record in this case. I'm looking at a sample contract. I think it's at record volume 2, page 19. And I'm wondering where it says that Capital Electric will be reimbursed for rental equipment.
Well, I think that's a good question, but I think if we look at substantively what took place, it was very clear that these charges were separately stated. There's no dispute, even the departments acknowledged that.
But you agree that the contract itself doesn't include a reimbursement provision?
Well, it doesn't specifically reference that word, but I think clearly to the extent that that contracts are clear that these charges are separately stated, and the expectation was that they would be passed through and that my client would be paid for. I think that's the essence of what a reimbursement is. And I'd also point you to the fact that when the department removed the charges for travel expenses, which the department included in this case originally and took them out only after this appeal was filed and some effort, when they removed those, they specifically indicated that those were reimbursements, and there's no difference between the way those taken care of and these. So substantively, they were the same. In addition, in some of the discovery responses that we provided as part of the interrogatories, my client indicated that the clear expectation was that because these were separately stated, they would be reimbursed. And that's exactly what took place. So I think, the proof is in the pudding. The manner in which they were handled and the expectation of the parties clearly indicated that the only reason why you'd separately state them and pass them through would be because there was an expectation that they would be reimbursed.
Now, counsel, if we look at the language of the contract, and I think it might be the addendum, which is, I think, record volume 2, page 20, it specifies that out-of-pocket expenses will be billed at cost. And then it also specifies charges for rental equipment, subcontractors, and any material will be billed at cost plus 10%, correct?
Yes.
So the contract treats the charges for rental equipment, number one, differently than out-of-pocket expenses, but number two, it treats it the same as it charges for materials and subcontractors, correct?
I believe that's correct. I think, but the clear expectation was in this instance that both charges be passed through. These were very, I think, as even the Board of Tax Appeals found, these were very specialized contracts. As I pointed out at the beginning, this is not, we're not talking about overhead here. And I think we dealt with that very specifically in our brief. From one contract to the next, Capital Electric wouldn't even know exactly what equipment's going to be necessary. That was dictated exclusively by the customer in this instance. They indicated what would be necessary, what equipment they might have that could be used by Capital Electric, and what additional equipment would be needed in connection with this. So from one contract to the next, you couldn't even anticipate. So the whole concept was, rather than you could have had a situation where the customer, in this instance, Westar, now Evergy, or BPU in some instances, they could have gone to somebody and said, I'd like to rent this equipment. They would have paid the tax on that. That would have been the end of it. We wouldn't be talking about this. But as an alternative, to simplify things, the understanding was, we will separately state this, you'll reimburse us for this, or we will reimburse you for this, cost plus the 10%, but it's been consumed by somebody else. In either instance, the result should be the same. If Westar had rented the equipment, they would have paid the tax once. There wouldn't have been any separate tax. What we're talking about is whether the department has the ability to impose the tax a second time.
And counsel, when your client used the equipment, you provided an operator who operated and performed services using that equipment, correct?
Yes.
Okay. I'd like to talk a little bit about the Cessna case. Are you going to talk about that again?
I was, yes.
Okay. And just specifically what I'd like to talk about is, I mean, I see a clear distinction, just to be frank, between the expenses in Cessna, which are consumed by the workers. We're talking about the workers' lodging, the workers' meals, the workers' travel expenses. Those are all expenses consumed by the workers. And the expenses here, which are services that are related to the contract. They're not consumed by the workers. They're costs that are related to performing the services that your client contracted to provide. So that's the meaningful distinction that I see. And so I'd kind of like to know what you think about that, just so I can be upfront with where I'm coming from.
Sure, I appreciate that, Judge. Well, I think in both instances, the services have been consumed by my client. And I guess, honestly, I don't believe there's really a meaningful difference between the two, because in the one instance, as I indicated earlier, you're kind of mobilizing your human capital, and the other kind of mechanical capital. But in the first instance, you needed the hotel rooms, to perform the contracts. They paid the tax on that. And even the department has acknowledged in this instance that my client was the ultimate user or consumer of the services for the rental and also for the hotel motel charges. And you can't resell something that has been consumed. And that was something that the court focused on in Cessna. They indicated that, notwithstanding a seductive aspect to the arguments made by the department and what was found by the board, they said when you focus on whether or not there's actually been a retail sale, there was not. Because in both instances we're talking about here, my client consumed the services with respect to the lease of the equipment, and they could not resell something. We could not have even submitted a resale exemption certificate in connection with those if we wanted to, because we weren't buying something that we were going to resell, nor were we purchasing services that we could resell. Those were consumed by us. Those transactions were over, and there was nothing more we could do to resell something that we had already consumed. And I think if you look even at the department's own materials, even though they're trying to create this distinction, they indicate that in these instances, contractors, subcontractors are obligated by law to pay tax as the ultimate user or consumer. And they actually indicate in their materials that, and it's bolded, that you cannot collect tax again. That would be consistent with the court's ruling in Cessna, which we think would be equivalent to what we're dealing with in this particular situation.
Council, this time goes by quickly. We're at 10 minutes, but I want to make sure that anyone on the panel has the opportunity to ask any questions that they would like of you before we move on. And so, panel members, do you have other questions?
Going back to the language of the contract, which lumps in the rental equipment charges, the subcontractors, and the materials all together. I mean, your client paid taxes on the materials that it used for the project, correct?
Yes.
And then it didn't deduct those taxes when it charged the client for those materials, right?
Well, any materials that went into, you would typically remove tax paid materials from your, I think even the department's own material, publications would indicate that either subcontractors or contractors would back out tax paid materials that went into the contract. Did
your client do that? I mean, I'm just looking at the language of the contract and how those three items were treated. Did your client back out taxes paid on the materials before it passed through the charges?
I believe that would have been the case here. I don't believe that was never an issue in this case. The department did not assess that. So to the best of my knowledge, I believe they would have, Judge, but that was not something the department assessed in this particular situation.
Okay.
Mr. DeFries, I have a question for you. You began your argument discussing burden. Would you like to discuss that specifically about the authority of where in the tax code the Department of Revenue is claiming they have a right to tax?
Well, I think in our brief, we had a section that cited several cases with respect to that, Judge. And I think it's been clear over the years that, like I said, in the case of exemptions, the burden's on the taxpayer to bring yourself clear within the statute. But with regard to imposition statutes, such as what we have here, the burden is clearly on the department. And even if there's any ambiguity, that must be resolved in favor of the taxpayer.
Are there other questions from the panel?
I don't have any right now. Thank you.
All right. Mr. DeFries, you have reserved 5 minutes for rebuttal, but if you want to take 30 seconds and wrap up this argument, you may do so.
I would like that. I think it gets to maybe some of the questions that we had here, but one of the things I wanted to cover is that this case does not involve overhead. I think we tried to very clearly address that in our brief. I think we did. If you just look at the dictionary definitions, if you look at the current case law in the state of Kansas, the department attempted to characterize both the travel expenses and the rental of the equipment as overhead. That simply is not consistent with the normal dictionary definitions. And I think that's the distinction that we think this court could make. If you look at something that was truly overhead, then we wouldn't be here today arguing that you can just separately state that and avoid taxes. But if it's not overhead and it's been consumed and there's no retail sale, then just as was the case in Cessna, that should be treated differently. It should be excluded, and you should not be expected to collect tax again.
Thank you, counsel. Mr. Beffert?
Yes, may it please the court, Your Honors. Jay Beffert again for the Department of Revenue. Thanks for this opportunity. I'll begin my responses here by noting in response to Judge Klein, or noting Judge Klein's latter questions in the last few minutes with regard to making a distinction between the Cessna case, in which the appellant seemed to be relying on a great deal. There's 4 main points that we want to make sure that the court understands with regard to Cessna. One is that the parties in Cessna stipulated that there was a reimbursement contract and that it existed. That's not the case. They directly did not stipulate this in this case. And again, I know that Mr. DeFries reviewed those facts, but I want to make sure that we emphasize these for the purpose of distinguishing the Cessna case. Secondly, the seller in the Cessna case separately invoiced Cessna for the agreed reimbursements. That wasn't the case here. These were not separately invoiced, as you noted, and I think Judge Klein noted a moment ago. Thirdly, the refund claim in Cessna was for travel expenses only, as opposed to differences in this case where we're dealing with the actual services that were provided. And the court in Cessna did make sure that was clear that that's a basis for the limitation of the language that they put in the Cessna opinion itself. If the seller had marked up the travel expenses, included the same travel expenses in its invoices to its consumers in the Cessna case, then I think the Cessna case would have been decided differently. And there's language in the Cessna case that actually recognizes that. Bear in mind, that's a 10-year-old case that was decided in 2012. Finally, there were no retail sales involved in the travel expenses of the seller to its consumer, so no retail sales may be applied in the seller's gross receipts. I think those are four critical distinctions to make the notation with regard to the Cessna case as applicable or as opposed to this case. Now, in the customary very good representation by Mr. DeFries and Mr. Weatharn, and I hope he's getting better as far as that goes, as well as Mr. Wolford, we note that that is an appropriate advancement of the Cessna case. However, we are concerned that by the court construing Cessna as the appellant is asking it to do, it's really expanding Cessna beyond what Cessna was intended for. It also goes beyond what the Cessna court noted in terms of its limitations within the language of the case itself. And again, following up on Judge Pickering's question about the imposition, indeed, the imposition of a tax statute or the imposition of a tax pursuant to a statute belongs to the assessing party. In this case, it's the Department of Revenue. We don't deny that. The imposition statutes are clear in terms of 3602 and then the definitions as well as the exemptions that are out there. The exemption, of course, shifts the burden back to the taxpayer. In this case, there was no exemption. We're dealing with purely an assessment based on the additional taxable services that were included, but not included as far as the basis for the return that was filed, which was eventually audited. So we agree that the imposition was met, that was imposed on us, and we also pursued that and met that burden. Are you poised for a question, Judge Warner?
Counsel, yes, I do have a question. Thank you very much. I understand your position with regard to Cessna, and I appreciate those 4 points. My question is, why wasn't Cessna discussed by either the department or the board in its discussion? That as a member of this court, I think that grates a little bit.
We think that Cessna wasn't discussed, Your Honor, and I've assumed this case from a recently retired attorney, so I go back from my recollection of the case. There are some significant uncontroverted facts that distinguish this from Cessna. For one, there's two distinct and separate sales occurred in these facts here. One was for the equipment rental. The other one was for the taxable service. There was no reimbursement contract associated with this. So Cessna, just on that fact alone, would seem not to apply. I think the board adapted to that, and I can't speak for the board. I can only reiterate what the opinion was from the board as far as that goes. But I think that's a distinguishing characteristic from the Cessna case versus this case. Secondly, the contract between the taxpayer and its customers was a cost plus contract. There was the rental equipment costs, which was marked up by the 10% figure. Now, interestingly enough, the initial assessment was for, I think, $217,000 or $218,000. And bear in mind, these assessments were done back 5 years ago. So we've got a significant time lapse that's associated with this. Ultimately, when the taxpayer provided some additional information, we back out all those travel expenses and what have you, which is associated from the language from the Cessna case. So to the extent the department followed the lead and followed the law that was required by Cessna, we backed that out and reduced the assessment by, I think it went down to $106,000, which was the part that was then appealed timely by the taxpayer and has gone up to, of course, through the Board of Tax Appeals and out to this court.
Counsel, if we agree with you that this case is different from Cessna, how do we outline that distinction in our opinion? Is it solely based on the nature of the two contracts that you're saying? That Cessna had a separate or reimbursement contract? Is that the basis for the distinction you're forwarding? Or is it that there is a meaningful distinction between travel expenses and these equipment expenses?
I think two things, Judge, and one is you hit the nail on the head with regard to the latter, and I think Mr. DeFries indicated before that there were, in the Cessna case, there were hotel rooms, travel expenses that were associated and built into the cost. I think the court troubled with that to make sure that those were excluded from the tax. So I think that it has to be a factual distinction, as you just noted in the last comment that you made. In other words, the last assertion that you made as a basis for distinction. Travel expenses, things of that nature, which are reimbursable and which we don't counter, we don't controvert with regard to the context of this matter. It is a difference, however, when you've got additional taxable services, not including travel or travel reimbursement, that are passed on to the customer, that are not a secondary source of taxation, but actually a second imposition moment, and that would be the basis for the other distinction. So we have a factual distinction as well as a legal distinction. And the third thing I might suggest to the court with regard to this is to look at the language in which the Court of Appeals in 2012 limited. I think they feared the concern, or had concerns and feared the expansion of the language from this, from the 2012 Cessna case, to apply further and beyond, which would really probably put, without using too many incendiary words here, a dagger in the heart of some of the imposition process through the Sales Tax Act. And I think this case illustrates where this would be misconstrued. And again, the very good advocacy by the appellant's attorneys here, which is very customary for them as far as that goes, I think it overlooks the fact of the risk of what could happen if the Cessna case is extended to the taxable services that are based on a second imposition situation there, and what it could mean in the overall FISC process.
So is what you're articulating the degree, and is it a factual finding that the department would have to make regarding the degree to which those services are tied to, or those, that equipment, those sales rentals are tied to the service that's being offered? Like, is it a spectrum that at some point those expenses are too far removed from the service to be tied to the service? I'm just trying to figure out how you're asking us to make that distinction going forward.
Your Honor, the court is always in an unenviable position trying to slice and dice circumstances like this. We think, well, for one thing, I think our auditors are trained as well as they're aware of the law. That's one of the reasons why in this case, particularly, they dropped all the travel reimbursement issues with regard to this and reduced the overall assessment. So I think if the court were to construe the limitations based on Cessna as it was and limit it to the travel reimbursement issues, that protocol that the agency would follow with regard to how it would audit these circumstances could be followed relatively easily, as it has been for the last 10 years. Is that helpful?
Thank you. Thank you.
Okay. Judges, just a few more, and I think I'm just kind of timing myself here. I think I've got about 3 or 4 more minutes just to follow up. I want to reemphasize the fact that in this case here, there were 2 distinct sales. There's the equipment rental sales, and there's the taxable services sales. I believe that the appellants have indicated that those seem to be subsumed one into the other. The reality is that they were 2 separate and distinct sales, and the stipulated facts reflect that. As a result of that, there is no double imposition of a tax on the same sales process. I think that's a critical distinction that we need to note here. There was a little bit, even in the Cessna case from 10 years ago, that seemed to be, the court was troubled by that, but the way that seemed to work itself out. And I think that that is probably a legitimate basis. Well, obviously is a legitimate basis because it's held for 10 years as far as that goes within the Cessna decision. However, in this case, it has to be noted that these 2 distinct sales contracts, one for the rentals and one for the taxable services, make it completely different insofar as distinguishable insofar as the imposition process. So very important to note. There's a couple of things there. I think Mr. DeFries indicated with regard to the ambiguities. The ambiguities that we do not believe are there.
Mr. Bedford, can you go back to the double imposition? Walk me through that again. I want to be very clear. I understand your argument.
Oh, sure, Judge. Well, there's 2 distinct sales here that we're talking about on these facts here. One is the equipment rental sales, and the second distinct sale was the taxable services sales. When we're dealing with the imposition of tax, and Mr. DeFries was dead on, that is dead right with regard to, we do not want to impose a sales tax on the same consumer twice. What we have here, though, are 2 separate incidents requiring 2 separate impositions. One would be on the equipment rental sales, which was what was done. The other one was the taxable services sales. It was that taxable services sales that raised the issue with our auditors, which initially indicated or resulted in the imposition of a $217,000 assessment. When we got the information with regard to the reimbursement for travel expenses, things of that nature, consistent with Cessna, we backed those out. So that would resulted in the reduction down to 106,000. Of course, there's been interest and what have you that's accrued on that since then. Is that helpful, Judge?
It is very, thank you.
Counsel, what's the
Okay.
meaningful difference between in your view, between the rental equipment sale or rental in which included sales tax, and the materials, the raw materials, which were taxed, and then the sales tax was backed out for purposes of the services sale, if you will?
Well, we think, well, the Cessna case gives us some guidance with regard to those items which had to be backed out. That's the travel reimbursement. We think Cessna is confined by the language of the court's opinion itself.
I want to interrupt you. I'm not talking about Cessna. I'm talking about so we've got materials and we've got rental equipment that are both I think in your view, and I'm not trying to put words in your mouth, but in your view are part of the services contract that are being offered here. But on the materials, we're not paying sales tax twice on those materials because the sales tax has been backed out of the contract. And so why is it that we can pay sales tax twice on the rental equipment?
We don't think there was a sales tax on the rental equipment the first time through. The rental equipment was the second contract. The equipment rental sales was the first contract. And that's where I think this case gets to be very distinguishable from the Cessna. And I'll try to avoid taking your Honor's cue about not going into Cessna, but making this case about this case. Two separate contracts, one being the equipment rentals, one being the taxable services. And out of those taxable services, we reduced or we eliminated the reimbursable travel expenses because of the Cessna case. And again, trying not to build this in. Honoring the law that's been set out by the Court of Appeals in that context was honored by that. Not sure if I answered your question, but I'm hoping I have.
I'm not sure, but at this point, I appreciate your answer.
Okay.
Counsel,
So in sum, Judge,
Counsel,
sorry,
along those lines, I understand that Capital Electric charged tax on their 10% markup on the rental equipment, correct?
that's correct.
So it's my understanding that they're saying, look, we charge tax on the services portion by charging tax on that 10% markup. How does that not fix the problem?
Your Honor, I'm looking through my facts here. I'm sorry, you kind of caught me at the quick here. I'm just want to make sure I get the correct answer before I answer that. Our understanding is that the third stipulated fact that we're talking about here, the taxpayer paid tax on the equipment rental, but failed to collect sales tax from its service customers on the equipment it rented and used to perform the taxable services. So I believe that's the answer to your question. I was trying to look for that stipulated fact, and there's an exhibit that's associated with that. I can cite to the exhibit here. It's number 9, lines 8, and from the motion for summary judgment. I wish I could cite to the record. I just don't have that specific record site available. I could get that to you down the road if necessary.
Didn't they charge tax on that 10%? I thought
We
they.
do not believe it was on it did not collect the sales tax from its service customers on the equipment it rented and used to perform the taxable services. So it is that portion there that was the basis for the additional sales tax assessment. And if I'm wrong with that, I'll rely on Mr. DeFries to correct me. Okay. So in sum, Judge, of course, standing for any of the additional questions that the judges may have, we believe that the Cessna case is distinguishable. And again, going off the basis of this case, we have two distinct and separate sales contracts. One was for the equipment, one was for the taxable service. It was the latter one that failed to include the sales tax, so it wasn't collected, wasn't passed on to the state of Kansas as a trust tax. And for those variety of reasons, I would ask that the court affirm the board's decision in this matter. And again, I'll stand for additional questions.
Thank you, Mr. Befford. Are there further questions from the panel?
No, thank you.
No, thank you.
Thank you.
Thank you.
Mr. DeFries, you have reserved 5 minutes for rebuttal.
Yes, and to be clear, unless I misunderstood, it sounded like the department just indicated that we had not paid tax on the equipment rentals, and that simply is not the case. We did pay tax. We consumed those services. The issue is whether the department can create a second transaction upon which tax also has to be collected. But any suggestion that we did not pay tax on the rental of the equipment is simply not true. I'm not quite sure where that even came from at this point.
Counsel, did your client charge tax on the 10% markup?
They did.
Okay,
Absolutely.
I thought it was just the rental cost that they didn't charge tax on. Is that correct?
Yes. Yes.
So am I understanding your argument that you're saying you tax the services part by taxing the 10%?
Well, that was the only part that had not been subjected to tax already. So we felt that by subjecting that the entire amount having anything to do with the equipment rental had been subjected to tax. And Judge Warner, I think you had asked a question of opposing counsel there with regard to how you would make the distinction. I think that's the same problem the department's had since they decided they really didn't want to talk about Cessna. I think you asked that question. They didn't like the Cessna decision. And I think when we took the deposition of the department's auditor, the auditor said, we still think those hotel motel charges are taxable. We think they should be. But ultimately, when we pushed in this case, they finally acknowledged that, well, I guess we're going to have to reluctantly exclude those. So they took them out. But I think the reason they were reluctant to take them out is because they knew they would have the kind of problem that you were alluding to. How do you distinguish? You can't. I think if you look at this situation, there's just no practical distinction between the two. The department has indicated in this case that they could find no statute or ruling of any sort that distinguished these situations. All they've ever pointed to is Cessna, and the only thing they've ever pointed to in Cessna is just the fact that the court said that it was related to the hotel motel charges. But when it comes to making a distinction, you just can't do that. Now, Mr. Beffert was indicating that they're just subjecting this to a totally separate transaction. No, what this court found in the Cessna was that the transaction was over. You can't resell something that has already been consumed. We did not sell those rental services to our customer. We consumed those and we paid tax on those as part of our transaction. You cannot, and the department has even acknowledged in the stipulation, well, not stipulations, but at least in discovery, you cannot resell something that has already been consumed. So this notion that you can create this second transaction and then say we're going to collect tax on it again is simply inconsistent with what we have in this particular situation.
Counsel, this might be an oversimplification, but if I were to contract with someone to replace my driveway, and that would be $6,000, let's say, to replace the driveway. That would be for the service of replacing the driveway, right? And it's not like I would get a contract that would say, well, the service of replacing the driveway is actually $2,000, and then there's a $4,000 rental equipment fee that goes on. I mean, it's $6,000 to replace the driveway. So how is that not different, or how is that different from the situation here?
Interesting question. Good question, Judge Warner. But I think that gets back to the comment by the Court of Appeals in Cessna when they said there is a seductive aspect to the department's argument and what the board found. But I think that gets back into what we were discussing with regard to the whole issue of overhead. Because if you were looking at that and you said we're going to replace a driveway for $6,000, there's some things that everybody has to have just as part of their overhead. What's unique about this is the very specialized nature of these contracts and the fact that you don't know what equipment you're going to need. So there'd be no way to build into your overhead equipment that you don't know whether you're going to need or not. And so that was the point of this. And you don't know whether you're going to need to have hotel motel charges and things like that. So in this contract, it was specifically contemplated that these items would be separately stated and then passed through the board in their orders specifically found that these charges were passed through. So the department would like to make something of the fact that there was not a stipulation or the contract did not specifically say reimburse. But if you have a contract that says we're going to separately state it, and the department even acknowledged when they pulled out the hotel motel that those were reimbursed expenses, arose by any other name is still arose. And so the clear expectation was that these things, those charges were going to be reimbursed in this particular situation. And so I think we would not be here. I would not be arguing that you can just, and I think this gets to what opposing counsel was suggesting. It's this notion that they made in Cessna also that this is going to open the floodgates. That's not the case. I think what we're asking you to do is simply look at in instances where there are separately stated charges that are reimbursed and that are not part of overhead, that those should not be subjected to another tax. If we were talking about something that was legitimately part of overhead, if the person that was going to replace your driveway had things that they always had to use for every particular contract over and over again over a period of 5 years, that's one thing. But if you've got things that you could have had Westar lease directly for you, or in this instance, the expectation was that Capital Electric would do it, that's a much different situation. I would not be here arguing that typical overhead, that you can just simply separately state it and expect. And I think that's the argument that the department seemed to make back in Cessna was that, well, if all you had to do, or they've even kind of hinted at it here, that if you just separately state it, then you could take out virtually everything. That's not a realistic argument, not one that I would make. But if it's not overhead, I mean, if it's truly not overhead and separately stated, and I would point out that
Council, I hate to interrupt you, but I have let you go over your 5 minutes. And so I wanted to make sure that there were no other questions from the panel. Any other questions?
Along those lines, I guess my concern is when we're talking about where do we draw the line, you're talking about specialty equipment that one contractor may or may not have. And in this case, you're saying your client didn't have certain equipment that it needed for certain jobs. So where do we draw the line? Because what if your client has equipment and it breaks down and they have to go rent something? Or what if they decide we're just not going to invest in that equipment and now we're renting all of our equipment? I mean, can't somebody game the system? Where do we draw the line with respect to these expenses and what is overhead and what isn't, just based on, how contractors, how they deal with it?
Well, I think that's a good question, Judge Klein, and I think we attempted to deal with that in our brief when we looked at just the common ordinary definitions of overhead, and clearly what we're talking about here would not fit that. I think you do get into a slippery slope when Judge Warner asked opposing counsel, where would you draw the line? I'm not sure where you would if you've got situations like this where you have something that's clearly not overhead, and my client doesn't even know for sure what equipment would or wouldn't be necessary until you get into the individual job and their customer tells them what's needed and what they may already have the equipment for, in which case you wouldn't have to deal with this issue. So I think the line that we've staked out for you with regard to whether it's overhead or not, and if it's separately stated, and if the expectation is it's going to be reimbursed, I think that's a reasonable distinction. It doesn't expand. I mean, it simply reflects what Cessna said. And that was, if confronted with other similar facts, our result would be the same. And if the department doesn't like that, then they could go to the legislature. And if they think there's something that needs to be clarified here, they could. But if it's not overhead and separately stated and reimbursed, then I think that the ruling should be the same. You should simply follow Cessna. And I think that's the reason the board perhaps decided not to get into this. They weren't sure where to draw the line. The department didn't even reference Cessna in their written final determination when they issued it, not once. So for whatever reason, folks haven't wanted to talk about Cessna here. And I think it may get to the point that you're raising in terms of their inability after 8 years to explain to us what the meaningful distinction between the two cases is.
I do have one question. My apologies. I know we want to end. Mr. Befford lists 4 distinctions from Cessna. The first one, stipulated to reimbursement. In your experience, is that usual to stipulate to reimbursement?
I'm
I mean, he's making it a factual, he's making a distinction. I'm trying to figure out if that's actually a valid distinction.
I think there was that stipulation in that case. I think there may be a reason, and I don't want to speak for the department here. There may be a reason why they didn't want to stipulate to that in this particular case because of some of the arguments that were being made. But I think if you look at the facts and you look at what transpired and the clear expectation of the parties, there's only one reason why you want to separately state that. And as the board found in their order, it was clearly passed through. You would only separately state it and pass it through if there was an expectation that you were going to be paid back. And the clear definition of paid back is reimbursed. So we can argue about semantics, but clearly there was an expectation that it was going to be.
And that's the second part. Is the second point he said was that it was separately invoiced. That's simply, would you say that's a distinction without a difference?
Well, the separate invoice and separately stated, the department acknowledged that it was separately stated, and the board specifically found in their order that it was separately stated. So I don't think there's any dispute with respect to that.
Thank you, Mr. DeFries.
Yes.
Any further questions from the panel?
Thank you.
Then, Mr. DeFries, you can have a couple of sentences to wrap up, and then we'll finish today's argument.
Well, I think, fortunately, based on the very good questions from the panel, hopefully we've had a chance to outline this, I think, very clearly. Our position is simply that in a situation like this, where you have separately stated charges that were reimbursed, and you have transactions where the item at issue has been consumed and you cannot resell them, that we cannot create yet another opportunity to impose tax on those. For that reason, we believe that there were sufficient facts. There weren't any disputes with the facts as found by the board. There were some others that could have been helpful, but we believe there's more than enough in front of you to reverse the Board of Tax Appeals and render a decision in favor of my client, Capital Electric Line Builders.
All right, we want to thank counsel for their excellent arguments today, both in the written briefs and in the oral argument. This case is deemed submitted, and we will endeavor to get a written opinion out as soon as we're able. At this point, we'll take a brief recess before the next case.
Judge Warner, does the court allow counsel to have a virtual handshake at the end of these proceedings?